Exactly 8:34 a.m. News and views right here on Salam Media. Our next guest is a legal expert and also member of Media Review Network. His name is Zaakir Ahmed Mayet, and a very big question being asked this morning regarding Masuku and South Africa as a whole. I should imagine is keen to know why a Chapter 9 institution HRC acted on behalf of the South African Jewish Board of Deputies to stifle free speech. Assalamu alaikum, Zakir. Welcome to the program. And a big question indeed, isn't it?
Definitely, and assalamu alaikum and good morning to all your viewers and listeners. It's a pleasure to be on the show this morning to discuss a very important judgment, I think, that has tremendous impact and has been incorrectly spinned within mainstream media. But to address the question that has been raised, why did the HRC push forward on behalf of the Jewish Board of Deputies? And this is unfortunate due to the structure and framework of the legal system. It went to the Human Rights Commission. It was then went to the Equality Court. They are obliged to then forward this information to the Equality Court as a party, as a complainant, and this was then appealed at the SCA. I'm more inclined and in favor of the Supreme Court of Appeal judgment in favor of Mr. Masuku. However, the Constitutional Court, the Apex Court, gave a different spin on it, and I have some qualms with regards to its interpretations, and I also have some qualms with regards to the manner in which it was structured. Some very concerning elements that came out of the Apex Court. However, it remains the final step within the legal process, and it does raise concerns as to whether or not the South African Human Rights Commission would pursue instances of Islamophobia, for example, with the same vigor as they have with this particular case. I think that it now does fall within our domain to test whether their responses and their sensitivities towards Islamophobic comments and commentary would be dealt with in the same way.
Uh, Quite a number of issues now, jumps out at me. And with due respect to the legal fraternity, I kind of wonder why different legal experts come up with different outcomes or judgments, and one questions, just how biased they are. That's a grave concern. I'd hate to come in front of the courts because they literally play God with your life. So that's the one issue. And then just to give context to, the matter that you and I are discussing, and that is that the Constitutional Court has given former COSATU International Relations spokesperson BonganiMasuku 30 days to apologize to the South African Jewish Board of Deputies for harmful comments he made against South African Jews way back in 2009. Way back in 2009. So let's unpack that, and also let's talk about the different outcomes by different legal experts.
Okay. I specialize in employment law, labor law, etc. And even within that particular framework, you have a difference in interpretation. And one of the key rules and principles is that you have to explain your case in such a way that the court or the commissioner or the judicial officer, whoever holds that position, understands and buys into your explanation of the facts. So yes, there may be a factual record, but it's the manner in which they interpret that record and interpret the law. Unfortunately, precedent in recent years, you'd look at the legacy of cases. This is the way the courts generally look at it. And you see precedent being flouted a lot of the time. In this particular instance, the Apex Court says that the Supreme Court of Appeal made an error in the manner in which they applied the law and which law was applicable. The SCA looked at the Constitution and based not because the SCA chose to do so. They said that because the referring parties, which was originally now on behalf of the South African Jewish Board of Deputies, their council, had foregone the reliance on the Equality Act. And only so far as the provisions that are outside of the Constitution, those they had foregone, but those that were in line with the Constitution, those are the ones they retained. So the SCA looked higher than the Equality Act and went straight for the Constitution and did the test according to a constitutional test. And there were multiple justices that had handed down that particular judgment. So I don't think that it was an error, to be honest. That's just my interpretation. I think the Apex Court had overstepped in this particular instance to place blame at the table of the SCA when it was actually the submissions by the council for the South African Jewish Board of Deputies, etc. So I think there was an error there. But it is unfortunately a character of law. It depends on the interpretation that you take, and some interpretations are, in some views and respects, more right than others. It's unfortunately, law is a gray area. That is why it's very difficult even to automate those type of things. It comes down to a value judgment. That being said, with regards to bias, and I'm deeply perturbed at certain elements, and I think I touched on it at the very beginning, is that I'm very particularly disturbed on two elements. The first is the manner in which the Constitutional Court dealt with Mogoeng-Mogoeng's recusal application. They effectively, and this is my reading of it, is they effectively saying that we are not held to the precedent of the JCC, the Judicial Conduct Committee, which found that Mogoeng had acted inappropriately, had ordered him to give an apology, and they make note towards the latter part of their judgment that the timing of Mogoeng's utterances on that webinar was very curious, in that South Africa was on the precipice of launching a very important resolution and conduct in support of Palestine, and his conduct then interfered with executive functions, undermined the position that South Africa was going to take, and he refrained from commenting during the I would call it investigation as to whether or not he had prior knowledge that this was a sensitive time. And the judgment goes on to state that if it was indeed within the knowledge of the Chief Justice, then this is an extremely serious offense. Now, the Constitutional Court and the manner in which they write these things, I think that is very concerning. They state that the complaint against the justice is simply about whether he loves Israel and loves Palestinians. That's not what he only said. It's an intentional warping of the facts. The Constitutional Court goes on further and says that we're not bound by the JCC. It doesn't set precedent. Fine, I understand that. But it does not mean that you turn a blind eye and you make your own interpretations of what was said. It was very clear that Mogoeng said the following. He said that it is religiously, and this is just a summary, I'm paraphrasing here. He says that religiously he's obliged not to curse Israel because it would curse himself and curse his nation. What does that mean? The ordinary understanding of the word curse is to speak ill of, to be critical, or to wish ill upon a certain group, people, country. Now, if Israel is committing crimes and Mogoeng holds the opinion that he cannot be critical of Israel, then surely that demonstrates bias, which the Constitutional Court refused to consider. So I think that that is a very serious concern in terms of biases. I think there's a problem here, and I think that the Constitutional Court is wrong. What's also concerning to me, and although this is not a legal challenge, but they end with a quote from the Torah. And I think this is overstepping on the part of the Constitutional Court. They are a court of law. They're not here to advocate any religious scripture or to interpret from a scripture or to even give us advice from a religious scripture, particularly when one of the groups that were challenging the statements of Mr. BonganiMasuku was from the Jewish community, and that is the claim that they made, that Zionism equates to anti-Semitism, being anti-Zionist equates to anti-Semitism, and that was more clearly defined within the SCA judgment. However, the Constitutional Court, by doing so, by electing intentionally to end their judgment with a quote from the Torah does place into question whether or not they correctly and objectively viewed this case. Regardless of that, there's an intentional incorrect spin that the media has given to the findings of the Constitutional Court, and I'm sure that we'll unpack it briefly as we go along.
Not have all that much time left, so let's just hone in on this issue regarding Masuku, where the court has asked him that he makes an unconditional apology to the SAJBD. But we also have a couple of questions from viewers and listeners, so let me get down to that as well. I'm going to hand over to you, hopefully without any interruptions. One more question that I need to get in there is that BonganiMasuku's taunting a reference to Jews who supported Israel as being friends of Hitler was especially hateful, and in view of well-known Jewish sensitivities over this tragic part of their history, was clearly intended by him to cause maximum hurt and offense. And this, of course, is, was quoted by Milner from the SAJBD. That's the one statement. And let's look at the two questions from our listeners, and that is number one: are we going to see many leaders toe the Zionist line because of this ruling? Question number two: are we going to see many leaders? Okay, same question, just asked in a different way. So, would you like to respond to that, please?
Yes, I think that there's two instances that we need to consider here. The first is the statement of Mr. BonganiMasuku on a blog called It's Almost Supernatural. It has a history of the blog of being extremely inflammatory. It is a very pro-Zionist blog. And what was intentionally missed, I think, and very little attention was given, although it was not subject of the legal inquiry itself, but I think it needed to be considered that Mr. BonganiMasuku's response didn't come out of a vacuum. What was said on the blog, and my apologies to the listeners and viewers for what I'm about to say, but it is the factual record, is something similar to the lines of these monkeys from Kosatu who rape babies to cure their AIDS, etc., etc., etc. It's not that Mr. BonganiMasuku, out of his own, spewed venom towards the Jewish community. It doesn't truly paint the context. He was infuriated, although it doesn't justify that statement that he made with regards to that. But it does provide a context. It is not how the Jewish Board of Deputies and anyone who supports that statement that was just read tries to portray it. So I think it's very important, and one lesson we need to draw from there, all of the leaders, those that hold positions, and even general public, those that engage on WhatsApp, those engage on Telegram, etc., we have to be careful in the way we express ourselves. Once something is put within a social media domain, set out in public, and even privately on WhatsApp, even amongst family groups, etc., you cannot undo that. You cannot take it back. And in anger, you may say something. However, it then does compromise the manner in which you exercise your rights. The right of freedom of speech and expression is limited. However, what is intentionally being ignored is that Mr. BonganiMasuku's statements at the rally at Wits, and funny enough, this was 2009. I was still at university at the time, and I was there. I was present. It was not Mr. BonganiMasuku who made the statement, Heil Hitler. It was Mr. Benjamin Schulman, who was part of the South African Union of Jewish Students, who then portrays himself in the SEA judgment to be an individual, common individual, which doesn't truly state the condition. My understanding is, from the information that I had at the time, that he had joined the Jewish National Fund shortly after campus. He is a prolific writer in support of Zionism and the crimes of the Israeli state. And he was the one that was chanting Heil Hitler, Heil Hitler. So it is very convenient, I think, for these complainants to utilize the word Hitler when it suits them. But when another party uses it, then it becomes problematic. But be that as it may, the statements at Wits University, where Mr. BonganiMasuku said that we will make life hell for those who send their children, means daughters and sons, South Africans, to go and fight and commit massacres amongst the innocent in Gaza, will make their lives hell in South Africa. Those were not considered to be statements of hate speech. So yes, he was ordered to apologize for the statement on the Supernatural blog, but he was not compelled to apologize for the other statements. The sum total of this case is that being anti-Zionist and being critical of the Zionist regime's actions does not equate anti-Semitism. The court stayed very clearly away from that. There was more clear and articulation of that within the SCA judgment. However, this is the sum total of the case. Yes, they are trying to hone in on minor victories now. Oh, yes, Mr. BonganiMasuku has to apologize. He only has to apologize for the one statement that he was, I believe, baited into. And he failed to control his emotions, understandably so. Doesn't make it right, the statement, but it comes out of a context. And the other statements, the two that they claimed were targeting Jews, inciting harm and violence, not at all. But there's one point that I would like to make. I'd just like to touch on the element of whether leaders have to be careful on what they say now. They're going to be fearful. I don't think so. I think the agenda internationally from human rights organizations, I'm talking Human Rights Watch, Beth Salem, I'm talking about Amnesty International with their latest reports, I'm talking about the recent statements made by Ehud Barak, who was prime minister, who was defense minister, he was also within the military establishment, and even Defense Minister Benny Gantz. Everyone is saying quite a similar thing, that Israel is now facing an existential threat. It is in trouble. It's, in my opinion, it's on its dying bed. Israel, despite its Abraham Accords and normalization with frontline Arab states, who were sellouts from the get-go, who sold the Palestinians out at the very beginning, these individuals have now come to the realization that Israel is an apartheid state. And the only reality that exists is the dismantlement of the state in favor of a one-state solution for all its citizens. It's not my words. This is what Human Rights Watch is saying. You have to dismantle the structure of Zionism. And Barak is saying exactly the same thing. We cannot be a democratic state and a Jewish state at the same time. We are an apartheid state. That being said, I don't think we can go further than that. Leaders have to speak out. That's the reality on the ground. And we should not be afraid of speaking for the truth.
We've almost run out of time. In fact, we're way over time. Two very quick questions.
Sure.
Is BonganiMasuku going to go forth with that apology just to get rid of this mess for once and for all? And we have a listener asking, has a precedent been set with this ruling, with this latest ruling?
Okay. Unfortunately, I cannot comment on whether or not Mr. Masuku would tender the apology. However, considering that it's now come from the apex court, and I think the one important thing that differentiates us from the Zionist regime and its supporters is that we play by the rules. We're not sending our daughters and sons to go and break the law abroad. We are not committing crimes and trying to justify it. We are not the individuals that are siphoning these fighters from South Africa into Palestine to go and commit massacres amongst the innocent. So I think it would be important to uphold the rule of law, even though we disagree in some respects. But I think it is important. In terms of precedent, I don't believe so. Yes, the Constitutional Court sets the precedents in terms of the legal frameworks, the highest court in the land, that is where you look at. But in terms of, and I'm talking not in the sense of law and judgments, I'm talking in the sense of practical application now, and how we conduct solidarity, events, statements, and our conduct as activists as well. I don't believe this constrains us in any manner or form. I don't think BonganiMasuku's conduct is one that should put fear into those that advocate for the Palestinian issue. The only thing that we need to draw from this, and I think we would, if we don't take this lesson, is that we must weigh our words extremely carefully. That we must consider what are the implications. Are we venting or are we speaking about truth and justice? And I think it comes down to a very clear point. If you speak on truth and justice, then you stick to the facts. If you speak from emotion and ego, this is when it becomes a precarious position and you can slip off that cliff very quickly. It's unfortunate that Mr. Masuku has done so, but in certain regards, I think he was completely justified in saying certain things, and that is what the Constitutional Court said. The 6th of February, yes, he erred. 5th of
Zakir,
March, no issue at all.
Zakir, I'm so sorry to cut in there. Brilliant
No,
interview with you. Loved it. Really,
alhamdulillah,
we've got to talk again sometime soon. Zakir
inshallah.
Ahmed Mayet. He is a legal expert and also a member of a Media Review Network. Lovely thoughts, lovely issues. I mean, pertinent issues that he unpacked there regarding the BonganiMasuku apology and the whole issue of the Israeli occupiers in the land of Palestine. The time is exactly 8:54. News and views with me, Julie Ali, right here on Salam Media.